The next case before us is State of Ohio v. Robert Davis. Each party will have 15 minutes to present their arguments. The appellant may reserve up to 5 minutes for rebuttal. If you do plan to reserve time, please let me know because I'll be keeping the time. The arguments are being recorded, so please stay behind the podium and keep your voices up. You should not use the name of children or minors or victims. During your argument, you can refer to them by initials or terms like the child. The judges have read your briefs and we are ready to proceed when you are. And would you, counsel, like to reserve time for rebuttal?
Yes, Your Honors, if I may reserve 5 minutes for rebuttal. And also I apologize for being late. It's on me, went to the wrong courthouse. Then they were letting me faster to walk, so.
Thank you, counsel. You may proceed when you're ready.
Thank you.
Thank you.
May I inquire, I just had this issue in the 5th District, will the court signal me when I'm close to out of time?
I will.
Okay, thank you. Good morning, Kimberly Kendall Corral on behalf of Robert Davis. I'd like, as we said, to reserve 5 minutes for rebuttal, and may it please the court. This case, the appellee and I disagree in our briefs about what standard of review is to be applied, whether that's de novo, and this court has found that where the trial court applies the wrong standard of law, de novo review is appropriate. The appellee has argued that where the wrong standard of review is applied, that is per se an abuse of discretion. Whichever standard this court applies, the outcome is the same. Here, the court had an obligation to follow the Supreme Court holding in Petro. The court merely cites Petro for the abuse of discretion standard, but then applies a standard set forth by the 7th District, non-controlling case law, in Brown, in place of the arguments and the standards and the factors to be considered in Petro. This is important because the court never does a materiality analysis, and that's an essential requirement before the court can come to an outcome. Here, the court's entire determination is based on a credibility assessment, finding that the sole witness implicating the defendant in this case, and that's the settled law here. This court has held that the only evidence implicating Robert Davis is the testimony of Mr. Williams. And so because we know that's the sole evidence implicating him, because that is the law of the case, that is the law of this court, the court is required not just to assess credibility. Petro doesn't allow for a credibility assessment by a sole arbiter. Here, the court says he lied in his first statement, he lied in his second statement. We think he was telling the truth when he testified, the only time he received a benefit, but we think he lied in his letters, he lied to the OIP, he lied in his affidavit, he lied in his testimony. And what we have here is we have a case that... If
I might interrupt.
Please.
Is your argument then under Petro the court had no discretion whatsoever and was required to schedule a hearing, a new trial in this case?
My argument is that the court had no discretion about whether to weigh the Petro factors, and that Petro is the controlling law, and the court did not weigh those factors. Now, I believe that weighing those factors, the outcome is determinative. He's entitled to a new trial. He's met all of those standards simply because the holding is the only evidence in this case is Williams' testimony. And what we have now is a situation where, reminder, Robert Davis is a child defendant. A child is convicted to a life sentence based on only the testimony of someone that the trial court and the state agrees is a liar. And they call him a liar repeatedly, both in the trial opinion and the trial briefs. Now, they rely on the idea that, well, the jury heard his testimony and found him credible. The jury did not hear his recantation, his years of letters, and all of those, and that's why Petro is not determinative on credibility alone. It requires a full materiality analysis of the entire record. There's not one site in the trial judge's opinion that weighs the effect of Williams' testimony against the volume of evidence against Davis. She merely weighs his own testimony against himself to come up with a determination that he's not credible, which leaves a person serving a life sentence on nothing but the testimony of a not credible person. It defies common sense, logic, and it's in violation of the law. It is an abuse of the court's discretion because the court is bound to follow Petro, and instead of following Petro, followed Brown, which one has not been adopted by this court and is not controlling law, and it's outside the scope of the court's role to adopt new law at the trial level. Now, if there's any question as to what Petro meant when it said that the evidence had to be considered in context in a materiality analysis, more recently, in 2021, in State v. Bethel, the Ohio Supreme Court was unequivocal that a new trial motion must be determined within the scope of the entire record. And that didn't happen here. There's no consideration of any evidence besides Wayne Williams' hearing statements.
Would you, I understand your argument to be, other than the testimony of Williams, there's no other evidence of Mr. Davis' guilt. Am I correctly saying that?
That's not just my argument, that's this court's holding.
Well, that's right.
Right.
That's what you're saying. So there really isn't anything else to compare the evidence to in this case other than Williams' testimony. Would that be fair?
That is fair, and because Petro requires that materiality analysis, and because in this unique situation, we have a holding from a higher court saying this is the only evidence implicating him, it's outcome determinative. In a different case where maybe we didn't have that holding, the court would have to remand for materiality analysis, but here, no materiality analysis can be done because it's a holding of this court that there is no other evidence implicating him. So no matter how you weigh Williams' testimony, once it's recanted, it's now a question of a fact finder to determine which of the many, many versions of his they believe, but for a judge to pick one version out of, let's say, 12, to decide that it wouldn't have made a difference to the jury when there's no other evidence to weigh against is in direct violation of what the Ohio Supreme Court mandates in Petro and again in Bethel.
So you don't think under Petro, the trial court, in this type of setting where there's only one piece of evidence, could say, I don't find this new evidence to be credible, therefore I don't think there should be a new trial?
No, and the word credibility isn't included in any of the factors in Petro. And again, credibility assessment is determined by Calhoun, and that's a determination of whether or not a hearing is warranted. We overcame those factors when we had a hearing. The state didn't cross appeal on whether that hearing was appropriate or not, and so that's not an issue before this court.
Fine, and trying to understand your argument in your brief, so I apologize.
Yeah.
You said that you analyzed those under Calhoun. Do you believe Calhoun is appropriate to assess credibility?
Calhoun is appropriate to assess credibility in weighing affidavits, and the term affidavit is very clear in Calhoun, and this court, specifically this court, has held, while it's true that other courts have applied Calhoun in new trials, this court has held that in State v. Jones, that Calhoun is not the appropriate standard to apply. And so that's the issue here. When weighing the affidavits, there was necessarily a credibility analysis under Calhoun. Those were the briefs that were presented to the court when the court granted a hearing.
So
Now the question is the material.
Calhoun only applies the question to grant a hearing review of the affidavits.
That is the express language of Calhoun, and this court has held.
Once a decision is made to grant the hearing, then the Calhoun factors don't apply.
Once the decision to grant a hearing occurs, the Calhoun factors don't apply because the Calhoun factors are to determine the credibility of the affidavits submitted to get the hearing. The question on Calhoun is whether a paper hearing is enough, whether the affidavits are enough. Here, we had the hearing, and what's appropriate at this phase is a materiality analysis. And that analysis, both under the longstanding holding of Petro by the Ohio Supreme Court and the newer and very clear, very express holding of Bethel, it has to be weighed in the context of the entire record. And that wasn't done at all here. You can look to the court's opinion, and there's not any consideration of any evidence, any other evidence which would support a conviction absent Williams' testimony.
Under this case, once the court had the hearing and was reviewing the testimony of Mr. Williams for the new trial, could the court compare that testimony to the affidavits that were filed with the motion for new trial by Mr. Williams?
Well, yes, to compare with the affidavits, correct. Is his testimony consistent with what the affidavits indicate? And in this case, it is. I mean, what he...
Just not use the Calhoun factors, the court would have to use some other factors to determine the testimony versus the affidavits. You would say, don't use the Calhoun factors, use some other general definition and standing for it.
The language of Calhoun and the holding of this court is clear that Calhoun applies to whether or not to have a hearing based on the affidavits. Once the hearing is had, the evidence to be considered is the testimony offered at trial. And there is testimony about the affidavits, but it is the testimony that's to be considered, not the affidavits. And so the cross-examination related to the affidavits is what the court should consider. It's what's the record in the hearing.
Were the affidavits admitted as exhibits in this case?
They were.
So in that regard, they're exhibits for consideration. Could the court consider them for credibility purposes as they were admitted for exhibits?
There's not a credibility analysis in front of the court. The analysis appropriate for the court is Petro, and that requires a weighing of the evidence against the entire record of the case, which didn't happen here. And that is an abuse of discretion, and whether reviewed de novo or an abuse of discretion standard, it requires a reversal. Mr. Davis is entitled to a new trial. The law does not support a conclusion that a person serve a life sentence on the not credible testimony of one person. Right? So we have a position where the state says you should maintain his conviction because Mr. Williams is not credible, and the trial court says we should maintain his conviction because Mr. Williams' testimony is not credible, but we failed to do an analysis of absent Mr. Williams' testimony, what evidence would uphold his conviction? None. None. And so Petro doesn't allow you to deny a new trial motion based on credibility alone. You have to do all 5 factors have to be considered, and they weren't. The court doesn't state or weigh the factors in reaching its conclusion because it chooses instead to apply a 7th district holding.
Counsel, I just want to let you know that you're at 5 minutes, so I'm not sure how much you wanted to proceed.
I will abstain for rebuttal.
Thank you.
Thank you.
Whenever the court is ready.
We're ready to make proceed.
Thank you. Good morning, and may it please the court. I'm Jacqueline Corrigan on behalf of the state to urge this court to affirm the trial court's decision because the framework of Ohio law actually requires a trial court to assess the credibility of a recanting witness's post-trial recantation, and the Ohio Supreme Court in Calhoun told them how. When the trial court in this case assessed Mr. Williams' post-trial statements in the light of his hearing testimony and his trial testimony and all of the statements that he had made in the exhibits in this case, and found that it all added up to him being incredible, it was following the framework of Ohio law, and thus it was following a sound legal process. It was not abandoning the clear legal standards that are in Ohio law to issue an arbitrary, unconscionable, or unreasonable decision that would have constituted an abuse of discretion. And since counsel has mentioned the Bethel decision from the Ohio Supreme Court, I would remind that court that in Bethel, as in State v. C, and this court in State v. Roper and State v. Jelowick, the standard to be applied by this court is an abuse of discretion, not a de novo standard, which means that regardless of how any member of this panel would have decided this case if they had been sitting instead of the trial court, you cannot reverse the trial court's decision merely because any member of the panel may have disagreed with it. Instead, the trial court's decision must be found by this court not to be supported by a sound legal process or sound reasoning process.
The appellant has a number of assignments of error. Some to me are, as they said, the court erred by not applying the Petro case. Would you think that is a de novo standard? The court had to apply a certain standard law and did not apply it?
Ordinarily, what's happened with, for instance, Roper and other cases with this court is when the trial court has abandoned an established legal standard and applied something else. This court has looked at that in terms of, did the trial court abuse its discretion? But the state submits that the trial court actually did, even though it did not cite all 6 parts of the Roper or the Petro test. The court actually did follow Petro, and I can explain to the court why. Okay, because as we know what Criminal Rule 33 requires, and the Petro test has 6 parts. One of which, the first prong, says that the newly discovered evidence, which is what a recantation is, has to disclose a strong probability that it will change the result of a new trial. Now, under Petro Part 1, if a recantation can't be believed, if it is not credible, it will not disclose a strong probability that it will change the result of a new trial. And that's that's the conclusion of the 6th District back in 1985 in City of Toledo versus Easterling, which came up with a two-part test that trial courts are to apply. And that is to first determine which of the contradictory testimonies offered by the witness is credible and true, and whether the recanted testimony is to be believed. And only if that recanting testimony is to be believed, then if that recantation is credible and true, only then can the trial court move on and determine whether the outcome of the trial would be materially affected by the recantation. And that's not just the 6th District in Easterling. The courts that have agreed with that include this court in the Covender case in 2008, this court in the Kimbrough case in 1995, this court in Augustine in 1993, and this court in Brown in 1990, and literally every other district court in this state has followed the Easterling test, if not explicitly by citing it, then by reciting the steps and following those steps, which requires a credibility assessment first.
Do you agree that the trial court was required to follow Petro and did so adequately in this case, or do you say the trial court did not have to follow Petro?
My argument, Your Honor, is that it did follow Petro. Whether or not it cited it and listed all the 6 parts of the test, it still nevertheless followed it.
And Petro was a controlling law?
Yes.
Okay.
Yes. And so the trial court did follow it, did follow the controlling law, and so only its conclusions are being brought into question here. And I would remind the court also that when it comes to a credibility assessment, that is always a matter within the trial court's discretion, which means that this court, again, has to review it only on an abuse of discretion footing. Now, one of the reasons why the credibility of a recanting witness must be assessed is because many courts have repeatedly said that there is no form of proof so unreliable as recanting testimony. And recanting witnesses and affidavits are viewed with extreme suspicion because witnesses, by making contradictory statements, either lied at trial or lying in the hearing, or both. And I'm not just saying that from me. That's from State versus Kernut from the 1st District in 1948, when my mother was 3, so it's long-standing law. That's State versus Gray from the 8th District, this district in Covender, this district in Elkins from 2003, and recanting co-defendants are viewed with even more suspicion. Allowing a co-defendant's testimony as newly discovered evidence, the 10th District said in State versus Prater, I quote, would encourage perjury.
Do you agree with the proposition of the appellant that the only evidence in this case linking Mr. Davis to the crime is Mr. Williams' testimony?
No, because there is also testimony from his sister and others that there was a time period when Mr. Davis's whereabouts were unknown, and that was roughly.
Appellant suggested, and I have not read our Court of Appeal decision on the direct appeal from Mr. Davis, but appellant asserts that this court found that the only evidence was, or this court ruled, I guess, the only evidence linking Mr. Davis to the crime and Mr. Williams' testimony. Is that true from our earlier appellate decision, in your view?
That was the language of the decision. I would submit it was dicta.
Okay.
It was not an actual holding by this court.
Anyway, the evidence you mentioned, the sister's testimony was evidence of Mr. Davis's guilt.
Yes, because it was, and of course, her testimony would be circumstantial evidence, of course, which does have the same weight as direct testimony or direct evidence, but she testified to a period of time right after the shooting when he was absent, as I actually laid out in the brief. So I think there's a clearer statement of that in my brief than I can make in the few minutes that I have.
Any other testimony other than the witness sister saying, I don't know where he was after this occurred?
I believe there was another witness. I can't bring the person's name to mind offhand, but I'm pretty sure I mentioned it in the brief, who also said that he was unaccounted for during that time period. But again, the Easterling framework, which this court discussed and adopted in Covender, dictated what the trial court was supposed to consider. And it had to consider whether Mr. Williams' statements during the hearing were credible or not. And regardless of whether it was based on the Calhoun factors or whether it was based on the general credibility assessment instructions that we would have given to a jury, just the general assessment of whether somebody is credible or not, Mr. Williams came up short. He was incredible. During that hearing, that trial court, I would remind this court sat through the trial in this case, did question Mr. Williams concerning the details of his newest story as to what happened, and found that not only was he changing it from, gee, Mr. Davis wasn't driving the car, to suddenly there really was no getaway car, and changing other important factors that he had.
But as to Mr. Davis, and go to the materiality argument, if I understand Mr. Williams' testimony, his testimony was, no longer did Mr. Davis have any involvement before the fact, saying, yes, I think we should rob this gentleman. He didn't drive the getaway car. There was someone completely different drove the getaway car. And lastly, they didn't share the money with Mr. Davis. So what exactly under that testimony is Mr. Davis complicit of? He said, I don't want to participate. He didn't participate. He didn't gain anything from the crime. What did Mr. Davis do in this situation? I mean, I appreciate you're saying it's not credible, that's all well and good.
Right.
But what did he do that's a crime if I believe Mr. Williams?
If you were to believe Mr. Williams, then Mr. Davis didn't do anything, as you said. But again, the question was not, did Mr. Williams do anything, or did Mr. Davis do anything? The question is, was Mr. Williams' statements that Mr. Davis didn't do anything, were those credible?
My concern of the judge's analysis is it was a lot of discussion about something that isn't relevant to Mr. Davis. What Mr. Williams testified about where he ran and where he went and where the car was. That, if Mr. Davis is the getaway driver, that's not relevant to Mr. Davis. Is Mr. Williams confused 10 years later about where the getaway car was? Okay. But how does that involve Mr. Davis?
It doesn't involve Mr. Davis per se. What it involves is Mr. Williams' credibility about what Mr. Davis may or may not have done. And that was what the trial court was trying to assess. Like I said, generally we look to see whether there is consistency in the versions of a story that someone tells, in material aspects. And when someone changes their story over and over and over again, which is what happened, in an unexpected way during this hearing. Okay, everything that everyone was expecting to hear from Mr. Williams, and in fact, what he did say when he was under direct examination and under cross-examination during the hearing was that the only thing that he was changing about the story that he had told at trial was that Mr. Davis did not drive the getaway car. Then when he was questioned by the trial court as to, well, how did this actually happen? Then he changed it, and when quizzed by the trial court, said, well, that's not what you just told us, that the only thing that you were going to change about your story was that Mr. Davis wasn't the driver of the getaway car. Now you're telling us there was no getaway car, or it was somewhere else, and you ran a completely different direction than the witnesses at trial saw you run that day. Okay, then that gives the trial court reason to disbelieve Mr. Williams based on whatever standard of credibility you want to apply. Whether it's the Calhoun factors, which the state submits is a good assessment even during a hearing, as 5 different other appellate districts have found. And the state would ask this court to adopt it too. But under any standard of credibility, trial court found that he was not credible, which is based on all the evidence before it, the evidence that came into trial, the statements that came in as exhibits, the statements he made at the hearing, everything.
So you would say that the appellant's argument they made earlier days, I understood it, was that the trial court wasn't able to take the testimony of Mr. Williams as a witness and compare it to the affidavits that were filed with the new trial is incorrect. And the trial court certainly should be allowed to look at the testimony of trial or new hearing by Mr. Williams and what he said in his affidavit. So that's something they can consider for credibility.
Well, I agree, the trial court has to look at all of it, at the trial testimony, at the affidavits, at the letters that Mr. Williams submitted, his hearing testimony. After all, when the Bethel case, when it says that you have to look at the entire record, that's the entire record. You have to look at it in that light. And I would remind the court that there was a long-standing list of times that Mr. Williams lied after this trial ended. He lied to the Innocence Project in 2017 when he told Mr. Davis's lawyer when he said that he told Mr. Davis's lawyer that he had, or when he said that he told Mr. Davis's lawyer that Davis didn't have anything to do with this. Had he told that to Mr. Davis's lawyer prior to trial, no lawyer worth their paycheck
We don't have any evidence whether that is or isn't true. The trial attorneys may have been told that, but just didn't ask any questions about it because they didn't think it was relevant. We don't know that. They didn't testify to new trial. We don't have any affidavit from those attorneys, do we?
We do not have any affidavit from them. I cannot imagine that they would commit malpractice in that manner, however.
We don't know that, though, to be fair. You're
Correct.
asking me to consider evidence outside the record at this point in time, other than your speculation that if they knew, they would have done something differently.
Well, it's an inference I would ask the court to make.
Sure.
But he did lie about meeting with prosecutors so many times that they made him believe that Mr. Davis was part of this. The evidence in the record is that the prosecutors only met with him twice. And the first time they met with him, by the way, was not because they were pressuring him to testify against Mr. Davis. Mr. Williams' attorneys approached the state to ask, can we get a deal for Mr. Williams in exchange for his testimony? That's not pressuring him to testify against Mr. Davis. Then again, like I said, he changed his story at the hearing, and he also lied to Mr. Davis himself when he promised that he had said, I am going to be working with the Ohio Innocence Project to help you, when he never did.
Counsel, we need you to wrap up.
Thank you very much. Again, credibility was key. Mr. Williams' credibility failed, and on that basis, the trial court did not abuse its discretion, and the state asks you to affirm. Thank you.
Thank you. Counsel, you will have your full 5 minutes for rebuttal.
Thank you. The court relied on Brown to go around the Petro standard, and I want to be clear that Brown cites Petro and Keenan for the holding that where the record contains competent and credible evidence supporting the trial court's outcome, that is not an abuse of discretion. Here the record does not contain any other competent or credible evidence. In fact, it's been determined by the court that the only evidence it relies on is not credible, which is the testimony of Williams. Remember, Williams gave several different statements prior to his version that he offered in trial. So if you use the same analysis that both the trial court and the state rely on in determining credibility, and you apply it to the entire record, well then his statement at trial is just as not credible as any subsequent statement. But remember, the statement at trial is the only time he received a benefit, a substantial benefit. He's out of prison already, despite his admission of participating in this aggravated murder. A substantial benefit, and he was threatened on the record in court with additional charges for this testimony, and continued to offer the testimony anyway because in his mind he believed it was truthful and it was the right thing to do. And so even if we think the courts can do a dispositive credibility analysis, which the law doesn't support, but even if it did, the way the court used its analysis to cherry pick predetermined outcome is an abuse of discretion. Had it applied that same analysis to all of the other statements involved by Mr. Williams, it would have come out with a determination that there's no way to determine what of his 12 statements were most credible, I'd say except the one he made over and over and over in letters to the Ohio Innocence Project, to our investigator in an affidavit, and to this court, which is that he lied about Davis being the getaway driver. He made that statement at risk to himself of additional charges. He was counseled, he was appointed counsel, and still decided to make the statement, and that statement is the only time where he wasn't receiving a benefit for what he said. And I want to draw to the court's attention a couple things. In paragraph 22 of its opinion, in making the holding a decision that on his sufficiency claim, the court says the only testimony implicating Davis was Williams' testimony that he was the getaway driver. I also want to posit that the state's assessment of the sister's testimony is inaccurate. This court found, its entire factual analysis is contained in my brief, that Jasmine, his sister, explained that Davis told Williams that he did not want anything to do with the robbery. Shortly thereafter, according to Jasmine, Davis came inside the house and the rest of the group left. About 5 minutes later, she heard gunshots. Jasmine testified that she and Davis went outside for a brief moment, went back inside the house, and then Davis left. According to Jasmine, Davis left on foot and walked down Princeton Street toward the location of the shooting. Now, that doesn't implicate Davis as a getaway driver in any manner whatsoever, and this court, in its prior holding, didn't find that it implicated him. The only evidence was that of Williams. Now, as to the court,
You're arguing that the trial court judge is finding that Mr. Williams' testimony is not credible is incorrect. Am I fair in saying that?
I think, so wait, my umbrella argument is the law doesn't allow for a dispositive credibility analysis to eradicate the Petro standards, right? The question is whether it's probable that it would have changed the outcome. When the testimony before a new trial would be that the only evidence implicating this person has been recanted, and then the jury has to decide what to believe in those 12 different statements, it's probable that that would change the outcome, but that has to be weighed against the entire record.
So the
and that's not just
credibility would come into that determination of whether it was probable or not probable that there'd be a new decision. Is that what's saying under Petro? I guess I'm kind of lost. You're trying to tell me that, I still don't understand. Are you trying to tell me there's no way whatsoever the trial court should have considered credibility?
the trial court should apply the materiality standards set forth in Petro. While credibility can be a factor of materiality, the question is, if this new evidence were presented to a jury, would the outcome probably have been different? And the court just didn't do that. Not by name or even without citing Petro. The court didn't engage in that analysis. It only determined whether in its sole discretion, in its belief, which is an abuse of discretion because that's not a determinative factor, this one version of Williams' statement is material. And there's one thing that Williams has been consistent with since he began writing those letters. Now we don't know, we don't have testimony from Ohio Innocence Project Counsel, so we don't know what was said to them.
Let's not speculate then.
And I'm not going to speculate, but we know what he says, what he testified he said to them, and there's something consistent there from the very beginning. He always knew that Davis had nothing to do with it, that he testified against Davis to get a benefit for himself, that he lied about Davis being a getaway driver. Thank you. And in conclusion, it is not just State v. Bethel, State v. Petro, but the United States Supreme Court has said that all new trial motions must be considered in the context of the entire record. So it is a holding of the highest court, not just in the state, but in the country. Thank you.
Thank you very much. Thank you both for your presentations. This court will take the matter under advisement and issue a decision in due course. The clerk of courts will mail a copy of that decision to you on the day it is released, and it will also be posted on the Ohio Supreme Court's website. This court is now adjourned